Good afternoon, everybody, and thanks for joining us for the September webinar program in our annual webinar series. And this is one of my favorites of the year, where we bring together team members from our various different practices. We call these our crossover webinars, where a subject matter is relevant both to the OSHA workplace safety, to the MSHA side of our practice, where there's unique aspects out in the state plans like California, where we've got a great team, and especially where we get to cross over topics with our labor and employment colleagues. And this is a really interesting one, talking about workplace crisis management. And I'm thrilled to be joined today by three of my partners: Rachel Conn, who is the chair of our California practice; Nick Scala, who's the chair of our MSHA practice; and Letitia Silas, who's the lead on our traditional labor practice based here in Washington, D.C. with me. I'll let everybody sort of say hello themselves, but we're not going to get bogged down in long self-introductions today, because one of the other things that I love about the crossover programs is there's so much content that we almost never can achieve this in an hour. But we're going to go as quick as we can today and try and get to the end of our slides. If we don't, certainly either way, we're going to make our slides available to everybody, and would be more than happy to chat offline with any of you about any of the topics that maybe we don't get to. Just as a very brief intro, I'm Eric Conn, one of the founding partners at the firm, and I chair the firm's national OSHA practice. And I'll hand it over to my colleagues.
I'm Rachel Conn, and I'm a partner in the workplace safety group, as well as the chair of the California practice.
Good afternoon, everyone, and good morning. My name is Nick Scala. I'm a chair of the MSHA practice group, which helps out mining companies across the country in a similar fashion to our OSHA side, and I'm also a partner in our OSHA practice group. I am based in our Columbus, Ohio office.
Hi, everyone. I am Letitia Silas. I am a partner at the firm's Washington, D.C. office. I'm a traditional labor and employment attorney, and I am leading the firm's traditional labor practice.
Well, I'm going to kick us off today by going over our agenda items. And the first, we're going to go through step by step in terms of crisis management. And of course, the first step is going to be crisis preparation. So pre-crisis preparation. So the things you should be thinking about in terms of, do you understand all your reporting requirements, the agencies that you need to report to? If you have facilities in different states, certainly not waiting until an incident happens to determine what the state requirements are for that particular area. Making sure that you have the right programs and procedures in place, looking at what are some of the potential crises that you could be having, and do your plans and procedures reflect that? We'll also be taking a look at what's beyond legal compliance. So the things such as, how are you communicating with employees? How are you setting up media? Do you have things in place such as, how you're going to be reviewing insurance and notifying them? All of the things that you certainly don't, again, want to wait till you have a crisis to consider. And then once the crisis has happened, what does that immediate response look like? Have you thought that through? Do you have that in place? Have you reviewed it, practiced, trained on it to ensure that in an unfortunate incident, something does happen, it isn't the first time that you're ensuring that what steps you have in place are operational? And also, what does recovery look like? So particularly out here in California, we recently went through this last year with the LA fires, and how, grappling with how companies and organizations deal with recovery and aftermath of things like that. Again, these are all things that you don't want to be thinking about in the moment. And hopefully, you can take this webinar, take these slides, and be able to prepare in these events for this. And Letitia will also be going through labor strikes and how you're preparing as part of that type of crisis management as well. And this is just some examples of the different types of crisis that, there is such a wide range. We're not just talking about, explosions or releases, but labor strikes, natural disasters, whether that be fires or floods, and also things, unfortunately, that are growing in the workplace right now, like workplace violence. There's been a study that recently came out that workplace violence is on the rise. So really, one of the things that we want you to take away from this webinar and think about is, what are all the potential crises that may affect your workplace? And do you have plans, reporting, recovery, immediate response in place to deal with all of those different types of scenarios? And we want to kick it off by, we're not going to get into the reporting requirements in huge detail here, but we certainly want to make sure and remind everybody that in any type of crisis, there might be multiple reporting requirements. And whether that's under Fed OSHA, if MSHA is applicable, all of the different state OSH plans that may have different reporting requirements, special requirements for chemical related events. And then, of course, things like with what you have to report to your insurance company to ensure coverage. So are you doing that timely and in a sufficient manner?
Right, and as Rachel said, I need to show constraint to not turn this into a reporting webinar and dig into the details of this, but we include this just to share that often when you find yourself in a crisis situation, you're focused on the crisis itself. You're focused on the immediate response. You're focused on the rescue efforts, and you're not thinking about reporting obligations. But the reporting obligations often have a finite period of time and often a very quick period of time to get this done in a compliant manner. And especially if we're thinking about this as crisis management, very often it is a fatality type of event, or those worst case outcomes where the reporting window is very brief. This is, from a Fed OSHA standpoint, that obligation to make that report to federal OSHA within 8 hours of when you learn that you have a reportable outcome. And then depending on if it's, no fatalities, but other really serious outcomes like multiple hospital, or now a single hospitalization, inpatient hospitalization, only 24 hours to report. So you're gonna have to move quickly on those things and make sure you're in compliance. One of the other big challenges for many of you, I know, big national employers or larger employers with facilities in multiple states, is to really understand the nuances and differences in the reporting requirements that might kick in, not just in those federal OSHA states, but if you're operating in any of these, the blue shaded states here with state OSH plans, you need to make sure you understand the different reporting obligations that might kick in any of those states. And I think Rachel, as the leader of the biggest state out there, can talk a little bit about some of those nuances and what the differences might look like and why it's important to really prepare ahead of time to make those reports as needed.
In this slide, we think this covers, the majority of the state plans with unique requirements, but certainly you want to make sure that you are reviewing any state that is not a Fed OSHA state and what their requirements are, because they certainly can differ, and you don't want to wait until an incident has happened and you're now trying to figure out what that state reporting requirements are. So, particularly here in California, where it's 8 hours and we have, certain unique pieces like permanent disfigurement, which we could kind of give a whole webinar on what exactly that means and how it's used. But that's a quicker turnaround than in some other places. And you want to make sure that you have that in place and the differences about, what may be a serious injury or illness in these different state plans, and making sure that your folks that are responsible for the reporting understand that and know the different mechanisms for that state and how to do it.
The next reporting obligation that we just wanted to flag for everybody is the Chemical Safety Board. This is a relatively new rule. I think it's less than a decade old, maybe about 5 years old, that this reporting obligation came into being. And it is one of these that a lot of employers don't know about, or a lot of employers don't think applies to them. They say, well, this is a rule for petroleum refineries and chemical manufacturing facilities. But it turns out it's a lot broader than that, and we've run into a lot of situations where the technical requirements of this reporting obligation have arisen for an employer that would not traditionally think of itself as within the scope of what the CSB does. And so they've missed this requirement. And what's important about this is the Chemical Safety Board has just started this year to refer failures to report over to the Environmental Protection Agency for enforcement. So this is something that if you don't know about this, it's a good time to learn about it and figure out if it might apply to you in certain circumstances. And it basically applies for accidental releases that result in serious injury, substantial property damage, or a fatality. So it's not just plants, chemical manufacturing plants or petroleum refineries. It's if you have an incident at your facility that involves the unintended release of a chemical that is defined broadly. It includes combustible dust. It includes things that would be, covered by your hazard communication program. Even if it's a relatively small release, if it results in one of those outcomes, a serious injury, a hospitalization to an employee, substantial property damage, which they define as $1 million, but it includes loss of use. So if you have to shut down some operation and that has $1 million economic impact to your company, that would be reportable as well. So this is not just for big chemical plants, but any facility, any operation that has a chemical related incident where a chemical is in a place it's not supposed to be, and it has one of these kinds of impacts. You got to make sure you understand this reporting obligation that may not be intuitive for many of us on the call.
Yeah, and then going to the MSHA side of things, it's a different animal, right? The federal MSHA, it does not have state plans. There might be some overlapping requirements with state plans. California being one of those states where Cal OSHA also has a mining and tunneling division. So you have to be aware of both of those requirements if you're operating in the mining industry out there. But overall, they have a consistent nationwide accident reporting rule. And it is a very quick turnaround. So being prepared and knowing how to identify what is a reportable event or accident is incredibly important. And also having that framework in place, I'm sure we'll talk about this as we move further down in the discussion, but having that framework in place so that people know that this is the requirement and how we move through the analysis, who's responsible for making the calls. And that all comes back to the fact that if there is an accident, as MSHA defines it, they must be notified within 15 minutes of the operator or an agent of the operator becoming aware of the accident occurring. That is a hard stop. If you fail to meet that 15-minute call, which they track when the call gets made to their hotline, you will receive a minimum penalty of at least $7,500 and change. And that can increase all the way up to MSHA's statutory maximum, or even beyond, depending on the circumstances there. But the idea being that operators, which includes independent contractors, have to be aware that if there is an accident that is a death at a mine, or an injury or an entrapment of an individual that has the potential to cause death, they have to be prepared to call the agency very quickly. Now, it is a squishy definition in some ways, especially when we're talking about how MSHA defines it and what they're looking at in terms of an event or an injury that could potentially cause death. The agency has taken a very, very, very broad view of an injury that could potentially cause death. So much so that there's currently, recent case long litigation out there where MSHA seeks that anytime that there is a head injury, regardless of the initially reviewed or expected severity of that is something that could have the potential to cause death, and that they should be notified. Additionally, this still applies in the context of a death of an individual at the mine if it's of natural causes. So if someone is walking from one part of the mine to the other and collapses due to a heart attack, MSHA still has to be notified within that 15 minutes. And it may not ultimately become an event which is characterized as chargeable to the industry, meaning it was not work related in MSHA's view. But nonetheless, the expectation is that they are going to be notified. And there's also, a series of very specific circumstances that MSHA includes in their definition of an accident. A dozen of them are up on the page, and then this is, calling the dirty dozen, so to speak, but this is what MSHA considers accidents for the purpose of being immediately reportable beyond a death or an injury that has a potential to cause death. But just, really be prepared, because once you make this phone call to the agency, it is going to be acted upon. There are going to be immediate callbacks. Once you speak to the call center, you won't immediately speak to someone from the agency, but a call center that answers, and then they will reach out to someone at the district where the mine is located. They will almost immediately call the operator at the number provided. They will issue likely what is a K order, as long as it's not a situation where they think it was maybe a heart attack, which preserves the scene. They will immediately marshal resources to have the closest inspectors come out to secure the scene, while they mobilize different investigation teams to come and follow up and take over. So the MSHA reporting, it's very quick turnaround. It's rooted in, mine disasters and the time that it can sometimes take to get to remotely located mines. But it applies even if your quarry is, a surface mine 15 minutes away from a major metropolitan area, or 15 minutes away or 5 minutes away from a hospital or other facility that can provide first responder services. So one of those things that you have to consider if you are in the mining industry, that this is a very, very tight turnaround comparatively. And I think Rachel, yeah.
And as I mentioned at the beginning of the agenda, one of the things that you should be considering as part of your pre-crisis preparation is reviewing the policies and procedures, the different programs that may be applicable in a crisis, in an emergency situation. And of course, again, starting with determining what are all of the potential crises, emergency situations that may be applicable to your facilities and to your workplace. Now, of course, that may not always be feasible to determine all of them, but you certainly want to go through that exercise in determining them, and then go through your policies and procedures and ensure that they are covering them and that these procedures are up to date. I can't tell you, for example, how many EAPs that I go through that haven't been updated in 10 years. And so it's certainly a good time to take a look at these procedures and policies and ensure that if there needs to be changes, those are being done. So here I've listed both the federal citations as well as the Cal OSHA citations. That's the 8 CCR citations you'll see there. And the reason that for that is because, as many of you know on here who work or have facilities in California, that's the state plan where you're going to see the most deviation from the federal plans. But that's not to say that the other state plans don't have their own unique differences, but we certainly want to call out California given their unique standards. So, of course, the EAP is going to be the biggest one that you're going to want to review and ensure that's up to date and applicable. Every employer must have a written EAP. And some of those requirements that are going to include in there are going to be reporting obligations, including fire or other emergencies or things that, again, are going to be applicable to your workplace and that you want to ensure that are covered. Names and contact information, making sure that you're training employees on the duties of this plan and the alarm systems. And one thing that I do want to note about an EAP that I see people neglecting many of the times is that your EAP should be talking to your other programs that may also be in play. So, for example, the biggest one that has come up the most frequently lately is workplace violence. Is your EAP and your workplace violence prevention plan, are they consistent? Are they working together? Are they saying different things? You want to make sure that those plans are talking to each other to the extent that these are going to be overlapping.
Chime in with one observation here that if you're not aware, federal OSHA has been working hard on an emergency response standard. This is not a standard that's in effect right now, but it is one that has gone through the notice of proposed rulemaking stage with a proposed rule out there with a comment period that has closed. I don't have an expectation that that rule will be finalized during the Trump administration, but I raise it here just as it's worth looking at to understand the agency's expectations and what they would consider to be, what they're hoping will become minimum regulatory requirements, but at the very least right now would be considered sort of best practices or expectations by the agency. And it is chock full of sort of planning. It's really more about emergency planning than it is what you do in the context of an actual emergency. There's all kinds of hazard assessments and emergency assessments and extensive training. Making sure that you are assessing the ability of your facility internally to respond to injuries or to crises, and the ability or the coordination with local emergency responders so that they are able to respond to the kinds of emergencies that you have, that you are continuously evaluating, sort of like a preventive maintenance program on your emergency equipment. Are you checking to make sure that the hydrants and the water supplies and the water pumps that you might fight fire with at your facility are functioning properly and fully charged? Are you ensuring that if you have emergency vehicles, that those are maintained and ready to go in the case of an emergency, and that you're doing the kinds of assessments you need to do to identify what kinds of crises might we experience, where in the facility, and what do we need to do to make sure either we can respond appropriately or that outside emergency response organizations are ready to respond. That rule, like I said, I don't think will go into effect anytime soon, but it's probably a good exercise to look at that and to study that and to see how your programs stack up with what OSHA thinks ought to be a minimum compliance program for internal emergency response purposes. That would be a good, I think, preparation activity at this point. And we've done a lot of work on that rulemaking. If you've got questions about that or want a little tutorial on what's in that rule and what you ought to be thinking about from an emergency response standpoint based on what's in that rule, definitely reach out, connect you with our colleague, Conn Carey, who's worked really hard on that rule and would be a good resource for that.
And moving down the list, also included on there is HAZWOPER, if that is part of what you are going to be implementing at your facility, and including your ERP there, which we'll talk about a little bit more in a second. HAZCOM, and just calling out that that's slightly different in California, that also incorporates Prop 65, which is not necessarily going to apply in emergency situations, but just to clarify that there are differences out there in California. And then, of course, bloodborne pathogens, and particularly those that are responding to an emergency situation. And recently, I've also seen situations where you may have Good Samaritans in your workplace that respond to an emergency incident and get exposure to bloodborne pathogens. And so ensuring that you're following your program, even if those folks that aren't part of your response teams do have exposure. So, the everyday employee that may get exposure as part of helping a colleague that has been injured as part of an emergency situation. So your emergency action plans, and again, this is just going through, we won't go into huge detail on this webinar about what needs to go in those plans, but just to call out for you as you go through them and prepare to ensure that they're up to date, to ensure that they're facility specific. That's one that I see all the time, not being put into place, that there may be a company-wide one, but not a facility-specific EAP, and different facilities may be subject to different types of emergencies. So just to keep that in mind, including procedures for emergency evacuation, include procedures for employees who remain to operate critical operations before the evacuation, address procedures for employees performing rescue or medical duties, and outlining the means of reporting to emergency responders. And of course, part of all of this process too is, do the emergency facilities around you, are they going to be equipped to deal with the type of emergency that you may be subject to at your facility? Just because there's a fire station across the street from your facility doesn't mean that they're going to be equipped to do a confined space rescue or whatever it may be that you may be subject to at your workplace. So certainly outlining what those emergencies are, and communicating with the emergency responders in your area to ensure that they can provide you the support that you need. And again, when we're talking about things like evacuations, that's again another great place where you want to ensure that it's talking to your other programs like workplace violence, which goes to things like, what are you going to do in an active shooter situation? That can be part of your evacuation protocols. And then for your emergency response plans, your ERPs, again, always to make sure that those are up to date and facility specific, establishing procedures for each potential threat, risk, or emergency scenario, account for the health and safety of site personnel in nearby communities, design response team, and assign personnel roles, including notification and activation, identify necessary response equipment, evacuation procedures, accounting for people, employee rescue procedures, notification requirements, and of course, with all of these programs, ensuring that training is done and conducted. You certainly don't want the first time that you're running through these procedures to be in an active crisis situation. And your emergency release drills for your facilities that are utilizing ERPs. Just a reminder that you're required to train site personnel on potential release response, conduct emergency release drills at the facility, implement best practices in compliance with local, state, and federal requirements, and implement lessons learned from training exercises, actual emergencies and event reviews, and making sure that you're also documenting those situations. Because I've certainly seen situations where the employers have done these things, and then when it comes to showing that these things have been completed in the past, there hasn't been documentation on site to show that they were conducted and lessons were implemented from those previous training exercises. And one thing that I do want to point out, again, for our facilities that are located in California, the injury and illness prevention program is going to apply to any crisis situation that doesn't fall under a specific regulation. So just because there's not a we have wildfire smoke, for example, that's going to be covering certain wildfire incidents, or will be covering all wildfire incidents, but any type of emergency or crisis that occurs, your IIPP is going to be covered by that. So ensuring that you are following the requirements of your IIPP for any potential event. And it's always a reminder that just because it's an emergency and just because it's a crisis doesn't mean that these standards and regulations do not apply. And workplace violence has been one of the rising areas that unfortunately we have seen as a crisis situation in workplaces. Again, I think I mentioned at the beginning of the webinar, there's been a recent study that's come out that workplace violence is on the rise. So again, in California, ensuring that your workplace violence prevention program is in place and that it's operational. We just hit the 1-year mark in July, and you have been required to do your annual review of that program. So great time to ensure, is this program working how it's supposed to be working? I tell employers all the time, you can have the most beautifully written program, but if it doesn't work in operation, it's not going to be effective. And that's what Cal OSHA is looking for. And we've already seen citations come out where Cal OSHA is not necessarily saying something's wrong with the policy or procedure, but they're saying that the plan was not effective. So again, ensuring that it does work how you intend it to work, and if it's not, that you're making those edits. I always consider workplace violence prevention programs to be almost kind of a living document, that if you're not pivoting and editing and updating it after incidents, then you're not going to have an effective program in place. And while at the federal level, there isn't a workplace violence prevention regulation in place, you certainly want to be reviewing for your industries specifically, and ensuring that you do have some type of workplace violence, anti-violence policy in place that you can have in the event that you do have an unfortunate incident. And I won't go through all of there's not specific elements. Again, it's going to depend on your industry and your facility, but we've listed out here for you some of the things to consider and that you'll want to have in those programs. And again, ensuring that they're effective, ensuring that these programs are talking to your emergency action plans as well. All of these should work together and be seamless when it comes to operation.
Yeah, and just to kind of tack on to that from what Rachel was saying on the effectiveness of the program with workplace violence, I mean, that is also something that we've seen at the federal OSHA level, where they have, we recently had a company that they said that they believed the policies existed, but the practice was not in place and wasn't effective as Rachel mentioned. So it's something that we also see at the federal level, to not just Cal OSHA specific. But in terms of emergency prep and rescue, the mining industry has some very specific requirements. It's going to be largely driven by the type of operation and mine that you are either operating or working in, if your company is an independent contractor serving the mining industry. And, potentially when we come down to the emergency response and the emergency action plans, the greater prescriptiveness from the Mine Safety and Health Administration comes to, and probably unsurprising here, underground mines. And in particular, there's a great deal more even regulation of underground coal mines as opposed to those in the underground metal side. So it's important, if you are especially an independent contractor who's venturing into mines across the spectrum, whether it's surface aggregate or precious metals or underground coal or underground metal, non-metal, that you're familiar with what these requirements are, what aspects have to be incorporated into your training program under Part 48 if you're going underground, or even what parts have to be approved by the MSHA district managers. And if you are a company that's operating nationwide, do you have the approval from each district that you're working in? So, this includes looking at what are the emergency response plans, what kind of equipment is maintained and how much equipment is maintained. Similar theories and thought processes as to what Rachel was just describing with other emergency response plans, but these are specific and prescriptive requirements that are laid out by the agency, the Mine Safety and Health Agency, regarding underground coal. Additionally, there are requirements for the establishment and coordination between underground rescue teams. And these teams are meant to kind of be either mine specific or regional, in that they service a group of mines in an area. And there are mandatory aspects that look at how quickly those teams can respond, how quickly they can mobilize, how quickly they can get to certain sites. And it kind of comes back to interplay with that 15-minute reporting rule, because most of these requirements were really codified along with the 15-minute reporting rule in 2006 in the Miner Act, which came into be after a series of significant mine disasters, most in the underground coal sector. But one of the big takeaways that MSHA found based off accident review investigation was that in one case, the operator had not contacted MSHA or any other mine rescue service for support for hours after an event occurred. And two, once they were able to do that, remotely located mines, as many are, especially in certain parts of the country, that it took hours after that for the mine rescue teams to be mobilized and arrive on site. And in that time, there could have been potential response that may have resulted in lives saved. So, make sure that if you're going into the mines, you're servicing the mining industry, or you're an operator, that you are aware of the specific requirements for your type of mine, whether you're operating in metal on metal or coal, and whether you're on the surface or underground, because the regulations for each one are slightly different, and you'll have to make sure that you're satisfying those, whether coal has mandatory requirements for response plans and approvals and evacuation and refuge, whereas that might not necessarily apply if you're a surface operation. Additionally, and again, similar concept to what we've talked about before, but the coordination with emergency responders and ensuring they have site familiarity and the capacity to respond to your specific site is another area that we see as a common pitfall on the mining side. And a lot of times we see this kind of as opposed to seeing these emergency situations at a large underground operations. We see a lot of this coordination kind of fall apart and be an issue of concern at small operations, especially rural operations that may not have the capacity to have these services on site with their team, but relying on local first responders. But they have not coordinated for site visits. They have not coordinated to make sure that they have the skill set or the equipment even to respond in the event of needing confined space rescue. I know is one that often comes up and that Rachel mentioned as well. But these need to be evaluated and need to see what your mine site specifically has in terms of potential for crises, and then ensure that you're looking at the applicable regulations to your type of operation, because they vary as to what's required, and then making sure that they're implemented. And a lot of those concepts obviously apply across the type of industry, but are especially important when we're dealing with underground operations. And with that, I think I'll turn it over to Eric here.
I think what we're getting into here is just, one of the major consequences of a crisis situation is, again, if you're, dealing with a scenario where an employee or a member of the public has lost their life as a result of an explosion, a release, a collapse, these workplace violence events, there is a risk of criminal consequences. And again, we're not going to go through all of the details of what constitutes a crime under the OSH Act or the Cal-OSHA Act or the Mine Act, but just to flag for you that that's one of the reasons, why you have to handle these situations differently than just, an ordinary employee injury, which we take very seriously under any circumstance. Why you have to take this more, handle this differently than other engagement with OSHA, MSHA, Cal-OSHA, or other regulators, because it's not just potential penalties, not just potential civil fines, not just your workers' comp exposure, but potential criminal charges against the company or even individual managers. And so on this slide, we talk about the principal criminal charge that is available under the OSH Act, and that is for a willful violation that is the direct cause of an employee death, can be charged criminally. Generally, that's going to be a criminal charge against the company, but in certain for small employers, closely held companies where there is an individual leader who is de facto the company, that could include charges against the individual managers as well. But there are also, other, and this is, again, just the elements of that particular criminal charge. But I want to go beyond that, and that's an extremely important one. That's something we deal with often, representing employers in fatality cases, is the potential for this criminal charge or referral to the U.S. Attorney's Office to investigate this and potentially prosecute this as a criminal charge. But it's important to know that this isn't the universe of potential criminal consequences that could arise from serious workplace safety accidents. There are, the full panoply of state level criminal charges that are available: negligent homicide, reckless homicide, obstruction at the federal level, obstruction at the state level, where you don't need all of these elements, because we're moving outside of this OSHAC charge, and it is not limited. In fact, it is more often the case that in those state level prosecutions that you are dealing with potential charges against individual managers as well. And then the other component of this, from a criminal standpoint, either at the federal level or at the state level, is the sort of what we call process crimes, and that's where successful preparation and successful management of a crisis is likely to avoid those process crimes where you're accused of manipulating evidence, creating false permits, lying during investigations and inspections by government entities. That those things can be charged criminally, and if you're not well equipped to prepare your employees for interviews with the agency, don't have counsel involved who are accustomed to dealing with these crisis situations, you're more likely to run afoul of those kinds of process crimes. And that's a situation you want to avoid, obviously. I think we get into the mine safety criminal consequences and some other state level items that my partners are going to talk about.
Yeah, and I think, similar to what we've seen throughout this presentation is with MSHA, it's very much like what we see with OSHA, with some slight wrinkles of differentiation. And I think I'll just add to what Eric was saying there, especially on the state level prosecution. I mean, there's also different timetables. And usually when we're talking about criminal referrals from the Mine Act or your OSHA investigations, I mean, that's happening far down the line from the time of event, even years afterwards, or at least more than years. So the difference, though, is some of these state level prosecutions can happen quite quickly. I know of recall an event in the mining industry up in I think it was New York or one of those states in the Northeast in the last few years, where their state level criminal prosecution had already moved to bring charges before MSHA had finished its investigation. So they don't always wait. They can be parallel tracks. But in terms of what we know with the Mine Act, it's similar, right? It comes down to willful violations, knowingly violating or failing to refuse to comply with regulations. And this can often happen after, significant accidents, significant events such as fatalities, crises such as mine collapses that we've been talking about throughout the day. But there's a few other wrinkles that I think are interesting. So MSHA has a section of the Mine Act that can result in criminal penalties if someone gives advance notice that an inspection is going to be conducted. And this someone can be employed by MSHA or employed by an operator or employed by no one that is relevant, right? Maybe just someone's friend or family who's relaying this information. Again, advance notice is not something that we usually run up against. It is rooted in this idea that they want to prevent the company from trying to hide or do a cursory repair of violations before the inspector can see them. That's at least the thought process behind it. But MSHA has warrantless search authority. They can come on site at any point in time to conduct an inspection. So they take this right of advance notice, or I guess this prohibition of it, very seriously. And we still see them come around every now and then. They're typically based off misinterpretations or, I think there's questions of the intentionality of it, but it is something that you have to be very clear about. And what we tell people all the time is with advance notice, be careful how you're communicating that MSHA is coming on site to do an investigation or even an inspection. It's usually not a secret that the agency is going to respond in the event of a serious accident or fatality at a mine site. We expect that. But if by chance MSHA is showing up for any other purpose and you're, radioing across the whole mine frequency that, MSHA is on site to do an inspection, that can be considered advance notice for the other parts of the mine. You need to have tailored communication, much like we talked about with the reporting requirement, that goes to specific individuals that need to know that MSHA is on site in order to exercise the operator's right to accompany them. Most commonly here, we see those process crimes related to events that Eric just described. Most of the people that have been criminally prosecuted successfully with MSHA were falsifying records of some kind or caught lying to the agency during the course of an investigation of some kind. It doesn't have to be just accident or fatality related. There was a mining company that recently had the company and individuals successfully convicted where they were falsifying required samples by not running them at the face of the mine where the work was taking place, but instead having the samples run in I believe it was a storage closet or something on the surface of an underground mine and relaying that data as accurate. So those are the kinds of areas that we see with the false statements. And then another kind of nuanced one is that persons who knowingly distribute or sell or deliver equipment to coal or other mines that they represent as complying with specific requirements of MSHA but don't, these persons can also be subject to criminal prosecution. So just some of the areas where the Mine Act slightly differs and has a bit more expanse and scope than what we see traditionally on the OSHA side. And I think Rachel now is going to talk about some of the state-specific items in California.
Out here in California, we have a specialized unit within Cal OSHA called the Bureau of Investigations, BOI for short, and their whole job is focused on reviewing serious workplace injuries and fatalities to determine whether or not a referral to the prosecutorial authority that oversees that jurisdiction is appropriate. So typically the district attorney's office. And so again, they're reviewing these cases that may involve they review any fatalities and certain serious injuries for whether or not these criminal violations have occurred. And it's really the only type of investigative unit like this in the nation. And they have a 3-year statute of limitations from the incident. So that means that you could get a set of citations, and those citations can be stayed pending the investigation by BOI. And, typically, or I would say in years past, they've been down in numbers. For the past couple of years, we've been down to 1 investigator in the state. And because of that, you may not even hear from BOI, or historically, you may not even know that the BOI investigation is occurring. A lot of times they may use the information, interviews, investigation, and inspection reports from the enforcement unit. But as of this last year, they're now up to over 10 investigators in the state. They have several attorneys that are now dedicated to overseeing these cases. And because of that, we've seen a increase in their activity and expect to see additional increases in their activity. I actually had a case last month that was an explosion, and BOI showed up for the opening conference. And I've never had in my career BOI show up to the opening conference. So just to give you an idea that they are in full force and being very aggressive in terms of their investigations. They also have subpoena power, and so you will see them also utilize that as well. And one of the other things that I would like to mention, similar to what Eric and Nick were talking about, is although BOI's sole job is to ensure that they do the investigation and potentially determine whether or not a referral to the DA is appropriate. That doesn't mean that that is the only mechanism for that. I've certainly had cases where BOI has declined to refer a case and the DA has still picked it up. I've had cases where the DA shows up and BOI doesn't. And I've also had cases under where the DA has brought them against a company under the California Business and Professions Code 17200, which is the unfair competition statute that basically, under the theory that if a company is not abiding by health and safety regulations, they're getting an unfair advantage in the workplace. And so I have seen cases like that. And those typically arise in situations where maybe there has been a history of fatalities, and the DA can't point to one bad actor or one particular program, what they consider more of a systematic culture of not abiding by health and safety. So they're just, BOI certainly on the rise in terms of aggressiveness. If you have a fatality, if you have very serious injuries or illnesses, or serious injury or illnesses that involve multiple employees, you certainly want to make sure that counsel is involved from the beginning to ensure that you're protecting yourselves in terms of potential criminal liability. And with that, I'll turn it over to my partner, Letitia, to talk about some of the beyond legal issues we have been talking about today.
Thank you, Rachel. So I like to call this beyond the legalese, because we know that when we are in an organization and a crisis occurs, we don't really think through all the legal hurdles, right? That's what the lawyers are for. But I want to talk about some of the things that we can think about and plan for from a practical and operational standpoint. Next slide. Let's see. So we want to make sure that you are identifying critical and emergency staff. And some refer to this as essential staff, like who is needed to run your operation. You also want to make sure that you have identified contingent or supplemental staff. Maybe that's some per diem staff that you have already enrolled in your payroll system and can be called upon on short notice. You want to think about alternative work arrangements and travel restrictions, if any. You also want to make sure that you're paying attention to your leave of absence programs, your benefits programs, and any other healthcare resources that may be implicated or called into play here. Finally, you want to think about return to work protocols and workplace security issues. Now, we're going to get more into this in the labor strike section, but it is still applicable here in the safety and health space. Also very critical is your communications planning and strategy. You want to make sure that you have identified a spokesperson who can speak on behalf of the organization. You want to make sure that you have identified someone who would respond to media inquiries and who media inquiries should be directed to. You want to consider engaging a PR firm, but that's something you should really think about and make sure that it's the right firm to represent your organization. That requires some advanced preparation and research. Consider social media monitoring so that you can keep an eye on what the conversation is about your organization and about the crisis. You want to think about a plan for speaking to families and employees, as well as any employee assistance programs. That's what my EAP is, right? Thinking about any programs you may have to help employees through the crisis. And here's some additional considerations. You want to make sure that you're not just training employees, but you're giving them information that's helpful. You want to consider having multiple locations for servers and any secure access resources that you will need. You want to determine steps to protect your supply chain and determine steps to ensure continued operations Again, we're going to get more into this in the labor strike section if we have time to get to that. And finally, you want to consider what role business can play in your response to the community. Now I'm going to turn it over to my colleagues to discuss some immediate response options.
Yeah, thank you. And so, kind of just building on that, what happens immediately afterwards? And I think we've talked about a lot of these concepts as we've been moving through today. So, we'll in the interest of time, we'll continue moving forward through them. But, what is your immediate response, especially in the context of workplace violence? Are you doing shelter in place? Are you doing an evacuation? This also, can apply when there's a release of an unexpected release of some kind. If you're doing an evacuation, just be prepared that you need to practice that, right? It is not going to be an effective mechanism if there isn't practice and there is an understanding of what people are supposed to do. And that goes throughout these considerations. You really need to train on that. You want to consider, are you securing your critical equipment and materials? Are you disengaging or turning off powered equipment or preventing against further harm that may transpire in the event that people are evacuated or are removed from a certain part of the operation? You need to consider that in your planning and your immediate response, because you don't want to necessarily hastily take action and then create a greater hazard either to the community, to the workforce, or to the facility by having people just flee without taking the appropriate steps. And additionally, you want to make sure that your people are going through the containment and mitigation process. So are they donning and doffing the appropriate PPE? Are they getting help for the injured personnel? Are they removing them from the situation which could cause further injury? Are you having a response that is going to evaluate and implement any containment options that need to take place? And then again, as we've seen before, consider the reporting obligations that there may be. Now, when we're talking about containment and mitigation, we're also talking about what controls are we using there. And, that has to be something that, again, has to be contemplated and thought through before the actual event takes place, because are we going to be using administrative controls or the use of PPE? Or do we have engineering controls in place which can be implemented to quickly either secure a scene or secure a process or contain a release that might be a more secure and a more thorough way to contain and mitigate further harm and also reduce the potential for exasperating the situation? If you have really situationally unique circumstances, you may rely heavily on PPE, but make sure that you have the right PPE, right? Make sure you have PPE that is rated for any specific substance or event that your personnel might be asked to or expected to engage with. And then make sure, again, and it goes back to the basics here, that they're effectively trained on when to use it, how to maintain and care for it as they push forward. In terms of kind of scene preservation, and the facility, whether it's a mine site or a factory or, a hospital, you need to try and initially begin to rope or barricade where the event took place. And that is to preserve the scene for an investigation, whether that is internal investigation or the investigation that might take place with law enforcement or regulators or anyone that might be having a stake in that. But also to prevent persons from accidentally accessing an area that could be hazardous to them. You want to prevent access to or prevent accessing or the removal of any equipment from the area until it's determined to be safe or investigations begin. Specifically in the MSHA context, there is a standard based off of the preservation of evidence. And if individuals either knowingly or unwittingly remove equipment from a scene while it is under a K order or prior to the completion of an investigation, this is grounds for a citation and can be a rather serious one. It also really tends to soil the relationship and the ongoing investigation, because now there's this thought that you could be attempting to manipulate the scene or hide evidence or remove material items from the scene.
One of the things, Nick, that I generally recommend to my clients in a situation like that to minimize the risk of a spoliation claim and to maybe earn a little bit of the confidence of the investigating agencies is to bring in a third party forensic expert. And for two reasons. One is I'm bringing in those folks with expertise to help with an investigation of whatever, is the foundational event of that crisis, but also to have somebody who is sort of a professional site management, professional evidence preservation, professional, expert in identifying relevant evidence, preserving it, developing protocols for how to preserve it, how to test it, how to, perform the kinds of testing that might be relevant to an investigation, and sort of remove the employer, remove the company from that decision-making tree and from executing on that. So you can say, look, if you're looking at whether we were reasonable and how we manage the evidence, we brought in this professional organization that does that, as a, as their profession. How can it be found that we were unreasonable in that regard? And often you find a lot more of willingness by the agencies, willingness by plaintiffs' attorneys, willingness by the insurance companies to defer to the expertise of that outside forensic expert in what evidence you're preserving, how you're preserving it, how you're moving it from the site of the incident to some off-site location, secured location, and then and some trust in how we're going to perform tests on that material, such that that's needed to be done for investigative purposes. So that there's a lot of risk involved in evidence preservation and evidence testing, and one great way to deal with that, minimize that risk, is to bring in a third party who's expert in those very activities to reduce your risk.
Yeah, and great points, Eric. And especially, if you are working with outside counsel, you can retain those experts under and through counsel in order to provide legal compliance assistance in the development and providing legal compliance advice, and therefore information gathered, and you have claims of privilege over it. I also think, one consideration is consider weather as a factor, especially if you have outdoor facilities or facilities that are suddenly outdoors because of the event that has just transpired. And if weather is a factor that has to be considered in preserving that scene and making sure you have that information, beginning to take those photographs quickly so that you can capture as much as you can in the timely manner and in the state of the event occurred will be helpful for when you have those experts come in at a later date. I think initially another item, and it goes back to what Letitia was just saying about communication, is, establishing people who are your leads to collect this information, to control the site, and to be these responsive individuals. And also making sure your team is aware of some of the best practices with regard to communications, right? Because, if we put an evidence hold on this, if there's a serious event, anything that's going to be collected and generated at this point in time may be subject to discovery at a later time. And that includes what is probably a means of communications that nobody thinks of in the moment as being a written communication, but text messaging. So be careful with that and make sure your people are trained or at least informed of the appropriate means of communication immediately after this. It's often difficult when we're going through the investigation and suddenly we were having to dig through months worth of text messages after the event in order to discover what exactly was said by who to who else in the immediate aftermath here, and whether or not that's going to be something that is discoverable in any potential litigation or investigations.
And I'll just quickly hit that certain states are going to have special considerations. So out here on the West Coast, we have wildfire smoke protections through several of our state plans. And I just wanted to hit quickly that, again, just because you're in an emergency, even if it's a natural disaster or an emergency crisis doesn't mean that other regulations don't apply. And I'll give you a great example of that is that during COVID, I had a client that conducted COVID testing. They decided to do the COVID testing outside because that provided additional ventilation. They thought that they were doing the safer thing. And lo and behold, they got a citation for not having a heat illness prevention plan for having their folks working outside. So certainly keep in mind that when circumstances change, even if your workplace may, for example, have working HVAC in a non-emergency situation, so you don't have wildfire smoke concerns or you don't have heat illness concerns, in a emergency where that HVAC's gone down, power's gone down, and now you have your employees working in those situations, you may have wildfire smoke regulations that apply. You may have heat illness regulations that apply, or other potential regulations that apply that you haven't previously identified as part of your safety program, but because of the changing circumstances, they now apply. So we just wanted to flag that you may need to be doing some additional hazard analysis given those changes in circumstances.
So now we are going to talk about a different type of crisis, and that's a labor strike. That is when the employees have decided that they are going to withhold their labor, which could significantly impair your operations, significantly impact your fiscal goals and performance, and also cause some damage to your reputation and brand. So, as many of you may know, federal labor law makes it lawful for employees, whether or not they are represented by a union. It gives those employees the rights to engage in what's called protected concerted activity concerning their terms and conditions of employment, in addition to the right to engage in union activity. And so that includes the right to strike concerning their terms and conditions of employment. That includes wages and hours. Also, to strike to protest unfair labor practices, or strike to protest unusually unsafe health and safety concerns at work, or to exert economic pressure on an employer to gain concessions at the bargaining table. Protected concerted activity can have long-lasting impacts on your organization. And so here are some key steps for preparedness and response to any type of labor strike or protected concerted activity. You want to make sure that you stay informed and stay dialed into what's happening in your organization in terms of your employee relations. You can learn a lot just from listening to what the employees are saying and what the conversation is around your workplace. You want to make sure that you are regularly conducting vulnerability assessments. You want to identify your operational, personnel, fiscal, public relations, and legal strengths, weaknesses, and vulnerabilities. You could also perform a SWOT analysis. You want to make sure that you know who your key stakeholders are. Those are board members, members of management, employees, community members, lawmakers, the media, and other notable figures. I can tell you that I have worked in-house as in-house counsel. I've held executive level roles within organizations, and I've served as a prosecutor for the National Labor Relations Board. And I can tell you that sometimes when a labor strike occurs or there's a protest about working conditions or just workplace conditions overall, sometimes someone who's totally unconnected to your organization will make a statement, especially in this social media space that we're in. I've seen celebrities opine on an issue, and that just really turns things in the wrong direction for an organization. So you want to make sure that you know who your stakeholders are internally and externally, as well as those influential figures who could impact your organization through their commentary. So you want to make sure that you prepare a strike readiness plan, and that's going to require some advanced actions. You don't want to wait until the strike breaks out. So your plan should include at a minimum the following elements. A way to engage your stakeholders. You want to manage expectations early. If you know that a crisis is brewing, that something is going to blow over, something is going to blow up, you want to make sure that you are starting to speak with your board members, speak with your management, speak to members of the community in advance to manage expectations. You don't want people to be caught off guard. You want to make sure that in doing that, you are building trust so that you can control your narrative. You also want to have a plan for clearly defining roles and responsibilities of the divisions and business units that are impacted by the crisis. Everyone should know their role and responsibility, and they should operate in their lane. I have seen internally where everyone wants to be an expert on things that is not their subject matter expertise, and it just causes more confusion in trying to respond to the crisis. You want to make sure that you have a method for ensuring safety and security of persons and property. You want to timely respond to significant safety and security concerns and ensure the ongoing safety and security of employees, customers, clients, and property. You want to coordinate and execute appropriate measures to ensure safe and unobstructed points of ingress and egress for non-striking employees, vendors, contractors, delivery persons, and other individuals who may visit your business. When necessary, you want to coordinate appropriate and proportionate mutual aid from local police and fire departments. And I want to put an asterisk here and spend some time on it, because I have also seen when an over-aggressive response creates a separate crisis. So you may have engaged police personnel to help de-escalate a crisis, right? Or a labor strike or some sort of protest. But how the law enforcement conducts themselves once they arrive on the scene is very critical, right? And so I have seen this occur where the use of force was called into play, and now that created a separate type of crisis that the organization has to respond to. You want to make sure that you have a plan for safeguarding the information technology infrastructure of your organization. That's files, databases, etc. You want to make sure that you have confidential IT personnel to collaborate with HR and key leaders to ensure the integrity of your business's computer network, systems, software, and equipment. You want to implement protocols to ensure the integrity and security of your networks, your email system, and yes, your social media platforms. You want to work with security officials to identify facilities or equipment that may require extra security measures. You want to make sure that you are taking steps to ensure business continuity. This includes identifying staffing agencies to provide temporary labor. This is also very critical when it comes to certain jobs that are typically not temporary jobs. So it's hard to find temps to come fill those roles. For example, if you operate a healthcare organization or a hospital, you know that getting techs is hard. And so if you are going to bring in temporary labor, getting technicians to do the tech work is going to be harder than getting maybe some traveling nurses that can come in and do some of the nurse work. You want to make sure that you are coordinating with contractors and vendors to maintain services, including the safe and timely delivery and transportation of materials, food, and other goods to your organization. I have also seen where you might have some employees who are represented by a union, they decide to go out on a labor strike. And because the delivery drivers are also, although they are employed by a different employer, they may also be in a union. They've decided to honor that strike line by your employees. And so now they refuse to deliver goods to your organization. So you want to make sure that you have a plan in place to respond to that. Along the lines of that strategic communication that we talked about earlier, you want to ensure the timely, accurate, and effective communication of relevant information to people who need to know. So you want to identify your need to know individuals and what they need to know, and plan your communication strategy accordingly. Next, you want to make sure that you have proactive management training. You want to educate your leadership, your frontline managers, and key stakeholders of the organization's legal and operational rights and obligations with respect to employees out on strike. Again, employees are given a lot of latitude when it comes to strike line conduct, right? And so conduct that would ordinarily constitute misconduct in the workplace may be protected conduct when it comes to being out on the strike line. So you want to make sure that you've trained your leadership and your frontline managers in those aspects, as well as their obligation to not threaten employees, to not retaliate against employees, to not interrogate employees, to not pull employees, or to not surveil employees engaged in a labor strike or any type of protected activity. Finally, you want to make sure that you are providing consistent and regular guidance and support to your business units. This next one is really key. You want to make sure that you have strategic human resources and payroll strategies in place. You want to assist management with attendance tracking, communicating with absent employees, documenting, and other appropriate actions. You want to coordinate with compensation managers and payroll and labor relations teams to ensure that wages are not paid to striking employees for time that they are not working. You want to work closely and coordinate early with the payroll department to make sure that the strike occurs at the if it occurs at the end of your payroll cycle, what that could mean in terms of time that's reported in arrears. You want to make sure that you timely and appropriately investigate claims of strike line misconduct or address employee concerns. Some other considerations you want to make with HR is, what are your requirements to continue to give healthcare benefits to employees who are not working because they are striking? You also want to think about, are you in a jurisdiction that allows striking employees to collect unemployment benefits? And what does that mean for you? You want to make sure that you are able to respond to the regular and constant inquiries from management and employees and members of the community, as well as lawmakers, about the day-to-day impacts of the strike. I led the University of California system through a 5-week strike by 3 bargaining units with about 48,000 employees in those units. Now, that's not to say that all 48,000 of them honored the strike line, but it was a significant crisis, and there were inquiries coming in on a daily basis from all these different constituencies. So you want to make sure that you have a means for responding to all of those constituents. Next, you want to make sure that you organize a strike rapid response team. That's your labor relations and payroll, human resources team. You want to make sure that you have security or personnel on hand. You want to make sure that you have members of the IT system, members of your legal team, your communications team, your public relations and government relations team, as well as your frontline managers who are going to serve as your eyes and ears. And finally, you want to make sure that you are enlisting the assistance of counsel when you need them. That's because, like I said earlier, conduct that may constitute misconduct in ordinary circumstances may actually be protected activity when it comes to engaging in a labor strike or other types of protected concerted activity. So you want to make sure that before disciplining someone or terminating someone's employment for alleged misconduct while out on the strike line, you are doing a legal analysis with your in-house counsel team or outside counsel. You also want to work with your outside counsel to determine whether or not seeking injunctive relief to enjoin the strike would be appropriate in your circumstances. So those are just a few of the things that you should take into consideration in preparing for a labor strike. And again, This could be done by employees, whether or not they are engaged, whether or not, I'm sorry, they are represented by a union. Now I'm going to turn it over to my colleagues. I know we're short on time. Sorry to rush through this, but they're going to hopefully bring us to a swift close.
Exactly. Thanks, Letitia. I think what we've got here is sort of the post-crisis situation, your incident investigation report writing and things like that. And I think what we're going to do here, because we have gone over, is to just wrap it up, but share these slides with you with a communication that follows the webinar. And if anybody has any questions or ideas or stories to share, or just want to pick our brain a little bit about the advantages or the pitfalls from incident investigations and incident investigation report writing, how they can be used proactively and against you, the advantages of doing this activity under attorney-client privilege, and how to execute that properly, please reach out. That's what this section of the program was about. And then we also have some slides in here about sort of recovery and restoration after a big event, like we've been talking about. So I really just wanted to get to the end here and thank everybody for joining us. Encourage you to check out our multiple different webinar series, the Labor and Employment webinar series with some great programs coming up for the balance of the year, our OSHA webinar series, our Cal OSHA webinar series, and I'm sure we've got our MSHA webinar series here as well. Make sure you check out our blogs and some of our special services. One of the things we've really started to do over the last couple of years is develop these masterclass programs. We talked about reporting a little bit today. We've got a great program on injury and illness record keeping and reporting to get your team in a position to do that flawlessly and efficiently. We talked about these emergency response events and crises management today. We've got a great OSHA inspection masterclass that does a deep dive into managing, the OSHA aspect of that crisis management when they're in the building, at the facility, at your plant, how to manage the flow of information and achieve success in that. A really terrific multi-program series on labor and employment relations, collective bargaining, and labor relations, a great program that Letitia and my co-founder, Conn Maciel, put on. And then we've got all kinds of great resources out there about California and national workplace violence prevention programs and training and all that good stuff. So if there's anything we can do to help, those programs are all related to the things we talked about today. Please reach out and let us know if that's something that we could do for your organization. Check out our blogs and join us for in-person events like our upcoming program in California, the Cal OSHA and California Labor and Employment Law Summit in October 21st. In Northern California, October 23rd. In Southern California, that's going to be an incredible program. So be sure to join us for that if you can. And thank you, everybody, for joining us today. And we will hope to be in touch in the future. Let us know if we can be a resource for you. Thanks very much.